On the 4th of January 2023, the disgraced founder and former CEO of now-bankrupt crypto exchange FTX, Sam Bankman Fried, pleaded not guilty on multiple counts of federal charges. Sam Bankman Fried's not guilty plea to several federal fraud charges was largely anticipated and condemned at the same time. It was something a few legal experts suggested was a tactical and calculated response. Hello. Today, we're looking at the recent twist in the FTX saga, in which Sam Bankman Friend has pleaded not guilty. The former CEO of FTX, whose company collapsed in November, made the plea in federal district court in New York. It's very common in the federal criminal justice system for defendants to plead not guilty at their initial appearance. Mary Beth Buchanan, former U.S. attorney now advising blockchain companies, said to TechCrunch, "The expedited timeline of FTX collapse and the legal actions against those involved was unexpected and unprecedented. Personally, and judging only from what is publicly known, I think the chances of a plea bargain at the outset of the case are very slim," said one expert. In a matter of weeks, Bankman Fried was hit with 8 federal charges. Meanwhile, his associates, such as FTX co-founder Gary Wang and Alameda Research CEO Caroline Ellison, confessed to various counts and entered into plea deals. But Bankman Fried pleaded not guilty because he had the absolute right to do so, Anthony Sabino, a law professor at the Peter J. Tobin College of Business at St. John's University, said. And it was the smart play. Keep your options open. Do not give the government an edge. Wait it out. A deal can always be made later. Sam Bankman Friend was arrested in the Bahamas and later extradited to the US. He's currently the center of arguably the biggest financial fraud in history. SBF allegedly scammed billions of dollars of FTX investors' money and used it for personal gains like flying in private jets, millions of dollars of real estate and more. Lewis Kaplan, the senior judge of the US District Court for the Southern District of New York, set Bankman Fried's next trial date for October 2. But not everyone expects that date to be set in stone or is confident that Bankman Fried will hold his plea until then. This is not a case where you want to either plead not guilty and wage all-out war or plead guilty and throw yourself on the mercy of the court, Fasanello said. The middle ground is the sweet spot here. Bankman Fried's defense team will need more time to prepare, given the expected mountain of evidence to sift through, Sabino said. Far more important, it is more likely than not that the prosecutors and SBF will talk a deal. So time will be needed to negotiate a plea bargain. In the meantime, if the opportunity arises for Bankman Fried to offer material assistance, such as substantial aid in the recovery of victims' funds or providing critical information on additional culpable parties, there could be an opportunity to obtain a plea bargain, Fasanello said. Personally, and judging only from what is publicly known, I think the chances of a plea bargain at the outset of the case are very slim. Considering Bankman Fried's rank in the supposed FTX fraud and his incapability of helping depositors prior to his capture, extradition, and arraignment, he holds minimal influence as a means for prosecutors to offer reduced charges or plea agreements. Consequently, Fasanello suggested, but if the circumstances change before his anticipated trial 10 months from now, perhaps the setting could be right for a plea deal, Fasanello noted. A case can be drawn out for months or even years, Buchanan noted. So it's really difficult to predict at this time how quickly the government will bring this case to trial. And that really depends not so much on the government, but it depends upon how many motions SBF and his team filed to attempt to exclude some of the government's evidence. This case is very important to the crypto industry as a whole because it should cause urgency to US regulators to move forward and regulate the space, Buchanan said. There are many things that regulators can do. If they regulate the space in the US, there can be requirements for client reserves. There can be requirements for auditing. There can be capital requirements to make sure that those who are participating on exchanges know that their assets are going to be available and can be regular audits. This case reflects the hawkish approach to oversight of the maturing digital asset space, Fasanello said. This is go time for the industry to button up and operate as the quasi-financial institutions, or even in many cases actual financial institutions that they are, and depart from the historically common misconception that somehow crypto is above the law. What do you think will happen to Sam Bankman-Fried? Let us know in the comments below. If you like this video, consider subscribing to the CoinEngine. We'll see you in another video.